The federal courts dropped a giant stack of filings yesterday. I read them all, so you don't have to. Happy Thursday, everybody. I'm Brian, and this is the morning report on the federal courts for August 14th, 2025. Do me a favor, guys. Drop a comment or a like and try to make it through the whole video if you can so we can get this out there. I've got a wrap on the Newsom v. Trump trial at the end, so stick around for that. Let's get to it. All right, we are going to start this morning with an update on Abramowitz v. Lake. Now, quick reminder, this case is about the U.S. Agency for Global Media, or USAGM. That's the parent agency in charge of Voice of America, and it's overseen by Kari Lake, who was an unsuccessful Senate candidate in Arizona, and I think a news anchor before that, something. Basically, right now, Voice of America is not operating, but its employees are still getting paid to sit at home because Voice of America is set up by law and can't just be shut down. So, the judge in this case first ordered Kari Lake to get Voice of America back into operation again as required by law. When she didn't appear to have done that, the plaintiffs filed a motion to basically force her to do that. In response, she fired the lead plaintiff, Mr. Abramowitz. That was last week, I think. Well, the judge, who is a Republican, by the way, if anybody wonders, issued what's called an order to show cause and said she needs to explain herself and show cause for why she hasn't complied with his orders. Well, yesterday, she filed that response, and it's a doozy. Basically, she says that Donald Trump has ordered Voice of America closed, and until Congress writes a law to close Voice of America, she's just going to keep doing what she's doing. Now, to be clear, I am reading a little bit in here. Let me give you her exact words. She says that the president, quote, has expressed strong interest in the public domain in closing USAGM, that's the parent organization. And as his politically appointed representative to run USAGM, I intend to help him do so within the bounds of current and federal law. But she's just finished explaining that what she's doing now is within current federal law, which the judge has already told her it isn't. Then she says, until such a time as Congress deems it appropriate to pass legislation to either close or reform USAGM, she's not going to go any further, basically, but she's also not going to go backward. Essentially, she told the judge where that order can go. Right up the robes. So judges don't love hearing that. We will see how the judge responds. All right, next we're going to hit New York v. RFK Jr. And this was a request from a viewer, but a very well-timed one. This is one of a number of cases about layoffs, and I know they all kind of run together, especially when the facts are really similar, but it's worth hearing how some of them are faring because they're very important to the people involved. Now, this case is about RFK Jr. and Health and Human Services trying to close some agencies within Health and Human Services and lay off a bunch of employees. And a coalition of state AGs has sued to stop them. And that's really important because it wasn't the employees in this case suing, but the states, because the states are worried that they'll lose services that they need without these HHS agencies around helping out. So that's an important difference to note. And there were some injunctions early on pausing these actions, but on Tuesday, the judge issued a revised preliminary injunction barring HHS from taking any action to implement or enforce the restructuring or reduction in force that they announced in March until further notice from the court. In response, HHS filed a notice of appeal stating that they're going to appeal this to the First Circuit. So that's our update here. Basically, for the moment, this is another set of big layoffs that's on pause, and we will see what the Court of Appeals says. Okay, next we're going to talk about two cases, Global Health Council v. Trump and AIDS Vaccine Advocacy Council v. Trump. These are two cases consolidated into one. This is one of those cases I sort of alluded to yesterday where we get into this gray area about exactly who is supposed to bring a case. And the answer can be really confusing. The rule is that only the person who is injured is allowed to bring the claim. So, simple example. If I get hit by a car and you are standing on the corner watching, you can't sue for my injuries. But sometimes the questions get kind of weird, like exactly who is the person specifically harmed when the president violates separation of powers? And that's what's going on here in global health. But I also want to point out that the news stories on this case are not covering it properly. The headlines I read said something like, appeals court allows Trump administration to cut billions in foreign aid. So let me give you the actual story here, compare it to that headline. Congress appropriated money to these groups, and the president basically wasn't giving it to them. So they sued on constitutional grounds, claiming that the decision by the administration violated separation of powers. The district court has been forcing the federal government to make the payments while the case progresses. But yesterday, the Court of Appeals overturned that decision because they said the plaintiffs here don't have standing. They aren't the ones with the actual injury from a separation of powers violation if that's the argument they want to make. Instead, the court said the Comptroller General might be the right person to bring that claim, who was a person that I did not know existed until yesterday. So compare that to the headline. And also, by the way, I've been watching the status reports filed in court, and almost all the payments in this case have already been made. So I don't think it's billions in cuts at this point. The government made most of the points already, but why get bogged down in facts? Now, this case could be appealed to the Supreme Court. We'll see. The Comptroller General could bring it, or if I understand correctly, these same plaintiffs could just bring the case under a different theory. But whether this was a good decision or not, I thought it was a pretty good opportunity to talk about standing, because it's a weird concept and a little hard to grasp. All right, bringing it home with Newsom v. Trump. Yesterday, I gave you an overview of the first day of trial. That was the plaintiff's day, and they had 3 witnesses, including Major General Scott Sherman. Second day was the defense's day, and they had 1 witness, also Major General Scott Sherman. And then on the third day, we had legal arguments. So I'm going to run through one thing that I noticed from witness testimony, and then just a quick overview of the legal arguments, and then I'm going to put a bow on this for now because what really matters is what the judge says anyway. So first, something that Major General Sherman said in testimony is kind of bothering me. Sherman was asked about a military operation at MacArthur Park in Los Angeles. And on the first day of trial, he said that before the operation, they assessed the threat level, determined it to be low or no threat, and that he had objected to sending in the military. And he got in big trouble for it. Now, this testimony could have been a problem because it sort of goes against the administration's narrative that the military is in Los Angeles to deal with these huge threats. But okay, put that aside. So on the second day of trial, they asked about MacArthur Park again. And this time he said, and I'm quoting here, "We assessed that there could be a large amount of people in the park which could quickly overwhelm Border Patrol," which does not sound the same as little or no threat, right? If I didn't know better, I'd say Mr. Sherman got yelled at on Monday night about his testimony, which, I don't know, just did not quite sit right with me. This might be nothing, but it rubbed me the wrong way. All right, let's hit legal arguments and we will put this thing to bed. Now, there are a ton of legal arguments I could tell you guys about. There are hours and hours of legal arguments. But if I had to narrow it down to a couple of minutes, I thought this was the most interesting thing that I heard yesterday, and I apologize if I'm going all law professor for a minute. I'm going to lay out 2 contrasting points that opposite or opposing sides made, because what I found fascinating here, and I think the judge agreed, is that both of them lacked something. And that may be the most important lesson here. When each side was asked to take a firm, immobile position, they both kind of fell short. Let me show you what I mean. So the big question here is when the military can be sent into an American state, particularly when the governor didn't ask for help. So on the one side, there's an argument that the military should only be allowed to protect government property or sometimes serve like a government function. I heard examples like when Nixon sent in the National Guard to deliver the mail during a postal strike, or when they helped FEMA with disaster relief. But that is a pretty restrictive view. Like, think of the kids in Little Rock in the 60s on their way to school who were protected by the protesters from the by the National Guard. That wouldn't have met that definition. Now, the other argument is that the only restriction on the president's power is posse comitatus, that law from the 1870s, which is a criminal statute. The president has criminal immunity, which effectively means there is no restriction on the president's power to send in the military, and that's exactly what the defense counsel said. So both of these arguments were used by opposing counsel on Wednesday. And the best takeaway, I thought, if I needed to boil down hours of testimony to a couple minutes, was that if both of these very smart lawyers are trying to pretzel themselves around the facts and law and make a rule that works, and this is the best they can come up with, extremely limited power or no limits at all, nothing with middle ground or flexibility, there just may not be a hard and fast rule that's gonna work here. And that might be the lesson. When everything is laid out, the answer to this question might not be as easy and clear as everybody seems to think. But that is what judges are for, I guess. We will see what the judge says. Okay, that is your Thursday morning report on the past day in federal courts. Again, drop me a like or comment, get this out there. I really do appreciate it. If you want to support me, there are links in my profile. And if you can pass this on to your friends who miss dry news, please share it. Otherwise, I will see you tomorrow. Same place, probably similar time. Thanks a lot, and have a great Thursday, everybody.